Imagine you are sitting in London, thousands of miles away from your spouse, thinking you are successfully renegotiating the terms of your impending divorce over, well, informal email exchanges.
All right, you think you have it all sorted out?
Exactly. You believe you are making your intentions clear to the court, only to discover that a legal ticking clock just hit 0 and you have been entirely silenced by the judicial system. Welcome to this deep dive. Now, kindly note that the contents of this discussion are intended for information purposes only and do not constitute legal advice. Please consult an attorney.
A very necessary disclaimer, yes.
Quite right. Today, we are undertaking a detailed examination of the intense judicial scrutiny applied to divorce settlement agreements, and we are using the pivotal 2025 case of Niewenhuizen versus Stanoycheva as our source text.
Yes, we are dissecting exactly why the courts refuse to merely rubber stamp agreements placed before them by divorcing parties. There's a profound tension in family law, you see.
The tension between party autonomy and the legal system.
Precisely. Between what the individuals desire to do with their own lives and assets, that party autonomy you mentioned, and the strict unyielding requirements of the law. Our objective today is to understand how the judiciary strikes a delicate balance here, ensuring private agreements meet rigid standards.
To understand those mechanisms, we really need to trace the procedural steps that brought these specific individuals before the judge. The factual matrix of Niewenhuizen versus Stanoycheva begins with a fairly standard timeline.
A very standard one, initially.
Right. The plaintiff sought to dissolve the marriage. As part of this dissolution, the plaintiff presented a deed of settlement to the court. Crucially, this document was originally signed by both parties on the 13th of November, 2024.
Yes, and the plaintiff requested that this specific November agreement be elevated to an official order of the court.
But then the complication arises.
Ah, yes. The complication arose entirely from the subsequent actions of the defendant. You see, the defendant was residing in London and had elected to proceed as a self-represented litigant.
Navigating the complexities of civil procedure without formal legal counsel.
Exactly. And from a completely different continent, the defendant attempted to initiate a new proposed settlement agreement, effectively trying to override the document signed in November.
So they communicated a change of heart, but did so outside the established rules of the courtroom. The source text identifies this as a critical procedural failure. How does the civil procedure framework actually handle this kind of informal intervention?
Well, the rules of civil procedure are highly structured to prevent litigation by ambush. When a plaintiff issues a summons, a defendant cannot simply send emails or draft alternative proposals to halt the process.
They have to formally file a plea, correct?
Yes, they do. A plea is a strict legal document that answers the plaintiff's claims point by point, establishing exactly what is in dispute. The defendant in London attempted to introduce new settlement terms without ever taking the mandatory step of filing this formal plea.
Which introduces the concept of the notice of bar. This is essentially a legal ticking clock.
It is. It's the mechanism the court uses to force progress. When a defendant fails to file a plea within the required timeframes, the plaintiff can issue a notice of bar.
A final warning.
Indeed. Demanding that the plea be filed within a strict, short period. If that timer hits 0 and the plea is still not filed, the bar falls. The legal consequence is severe.
So the expiration of this notice meant the defendant was legally barred from formally pleading their case.
Precisely. As a direct result of this failure, the matter proceeded unopposed before the court.
You know, it is akin to attempting to submit revised architectural plans to the municipality for a new building, but refusing to fill out the mandatory zoning form.
That is an excellent analogy.
Right. You might have the most beautifully drawn blueprints.
And you might have couriered them directly to the mayor's office.
But the municipality can only adjudicate the paperwork officially and properly before them. They cannot bypass their own zoning laws, regardless of what is sent to them informally.
The court operates within an even more rigid framework of rules than a municipality. Because the defendant failed to observe the procedural requirement of filing a plea, resulting in the expired notice of bar, the court was compelled to entirely disregard the informal attempts at a new agreement from London.
The new proposals legally evaporated.
They They did.
Uh,
This procedural reality left the judge with only one valid document to consider.
the original deed of settlement signed by both parties in November 2024.
Just so.
So, because the informal communications vanished from the legal perspective, the judge was forced to evaluate the standing of that single November agreement. This requires us to look at how a judge actually decides if a piece of paper is legally binding and worthy of becoming a court order.
Yes. The central statutory provision in this scenario is Section 7(1) of the Divorce Act.
And Section 7(1) provides the specific mechanism for what we term the patrimonial consequences of a separation.
Exactly. Which refers to the division of assets, the allocation of debts, and the restructuring of the parties' financial lives.
The law recognizes that it is generally highly efficient for parties to agree on these financial outcomes privately.
It is. Section 7(1) permits them to draft these agreements in writing and submit them to the court to be incorporated into the final formal divorce decree.
But the court does not accept these written agreements automatically. The source text emphasizes that Justice du Plessis applied established legal requirements from a precedent-setting case, Eek versus Parsons.
Eek versus Parsons. This is fundamental because it establishes a strict threshold. A private contract between two individuals is fundamentally different from a court order.
Because when it becomes an order, it carries the full coercive weight of the state.
Indeed. If you breach a court order, you face potential contempt of court proceedings. Because the stakes are elevated so significantly, Eek versus Parsons dictates that courts cannot simply rubber stamp agreements. Justice du Plessis meticulously evaluated the November 2024 agreement against three mandatory pillars established by this precedent.
Let us examine why these three pillars exist, rather than merely listing them. The first pillar requires that the agreement must be directly related to the dispute between the parties.
Yes, this requirement prevents the abuse of the judicial system. Parties cannot use a divorce decree to sneak in unrelated commercial contracts.
Or settle disputes involving third-party business entities that have nothing to do with the marriage.
Precisely. The court's jurisdiction in a divorce trial is strictly limited to the marriage and its direct patrimonial consequences. If a clause strays into unrelated territory, the court must reject it.
The second pillar states that the agreement must be non-objectionable in its terms. This seems to be where constitutional safeguards come into play.
They do. A court cannot issue an order that violates public policy or the law, even if two parties willingly agree to a term. If that term is oppressive, illegal, or infringes upon the constitutional rights of one of the parties or their children, the court must refuse to endorse it.
The judiciary acts as a gatekeeper here.
Quite right, ensuring that the supreme law of the land is upheld even within the private sphere of a divorce settlement.
Now, the third pillar requires that the agreement must offer practical advantages. This speaks directly to the functionality of the law.
The court is highly concerned with enforceability. There is no utility in issuing an order that is practically impossible to execute.
If an agreement contains vague promises or requires actions that are geographically impossible,
It offers no practical advantage to the parties. It would merely lead to further litigation, you see. The court must be satisfied that the terms provide a clear, executable resolution.
and in the matter of Niewenhuizen versus Stanoycheva,
The court analyzed the November 2024 deed and found that it successfully satisfied all three of these foundational pillars.
I must present a challenge on behalf of you, the listener, regarding this outcome.
Please do.
If the defendant clearly wanted a new agreement and communicated this desire from London before the final decree was issued, why would the court enforce the old one? Doesn't the fundamental concept of voluntary mutual consent dictate that the most recent wishes of the parties should determine the final outcome?
That question addresses the absolute core tension of this ruling, and the answer is found in the vital principle of procedural discipline.
Procedural discipline.
Yes. While mutual consent is a cornerstone of drafting the contract initially, the transition from a private contract to a court order requires strict adherence to procedural law. Mutual consent was definitively established when both parties applied their signatures to the original November deed.
And the court found that the defendant's subsequent attempt to withdraw that consent was procedurally defective.
Exactly. Due to the failure to file a plea.
So the argument is that you cannot selectively participate in the legal system. You cannot ask the state to formalize your affairs while simultaneously ignoring the procedural mechanisms the state requires.
The court cannot bypass procedural law simply because a self-represented litigant changes their mind informally from abroad. Procedural rules exist to ensure certainty, predictability, and fairness.
If the court allowed informal emails to override signed agreements after a notice of bar had expired, it would create chaos in the legal system.
It absolutely would. The plaintiff, who followed the rules, would be severely prejudiced by the defendant who ignored them.
This strict adherence to procedure reveals a much broader philosophy about the role of the judiciary in family law. The court will not abandon its established structures to accommodate informal changes.
No matter how clearly those changes might be communicated outside the formal legal channels. This leads to the broader implications of Justice Duplessis's judgment. The case serves as a definitive ruling on judicial oversight.
The judiciary holds a profound responsibility here.
They are not administrative clerks stamping paperwork. They are constitutional adjudicators, ensuring that the power of the state is deployed fairly and lawfully.
The source material specifically emphasizes those constitutional safeguards. Settlements must be critically examined for both legality and constitutionality.
The court engages in a highly delicate balancing act. On one side of the scale, you have party autonomy, the recognized right of individuals to decide their own patrimonial consequences.
Yet, on the other side of the scale, the court must uphold those strict constitutional safeguards. The autonomy of the parties is not absolute.
It cannot supersede the requirements of the law or procedural fairness. Judicial oversight is the vital mechanism that maintains this equilibrium.
Verifying that the agreement doesn't violate procedural rules or public policy.
Indeed, and verifying it possesses the necessary practical advantages for a functional legal order.
Let us distill the practical takeaway for you, the listener. Whether you are studying the law, practicing it, or navigating these waters as a litigant, the directive from this case is unmistakable.
Effective settlement agreements require meticulous drafting and absolute adherence to requisite legal standards.
Procedural shortcuts, informal amendments, and assumptions that the court will simply figure out what you meant, these are simply not tolerated by the judiciary.
The standards are exacting by design. You cannot circumvent the fundamental rules of court, such as filing a formal plea, and expect informal communications sent from another continent to alter a signed legal document. Meticulous preparation is a non-negotiable requirement.
To consolidate our analysis, the case of Van Niewenhuizen versus Stanoycheva reinforces that voluntary mutual consent must always be accompanied by strict procedural discipline. Courts will vigorously scrutinize settlement agreements.
Applying established precedents such as Eek versus Parsons.
Precisely, to ensure they meet all legal, practical, and constitutional requirements before elevating them to the status of official court orders.
I would offer a final provocative thought derived from our analysis today. Consider how the strict requirement for procedural discipline, which can often seem overly formal or bureaucratic, might actually be the ultimate protector of fairness in family law.
A protector rather than an obstacle.
Yes. When one party is thousands of miles away in London, operating without legal counsel and attempting to change the terms of a settlement, it is the rigid, unbending nature of legal procedure that protects the process. It ensures that neither party can unilaterally ambush the other with informal changes.
The strict rules are not the enemy of justice. They are the very framework that guarantees it.
Precisely.
That is a compelling perspective on the protective nature of procedural law. It frames the rigidity of the courtroom not as an obstacle, but as a necessary shield against chaos and unfair prejudice. We thank you for joining this professional deep dive into family law, judicial scrutiny, and the paramount importance of procedural discipline.